Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Welcome. How are y'all doing today? We are waiting for the Karen Reed motion hearing to start. Let me pop it up on screen so you can see. I am doing a dual live, so I have a live right now going with the Twisted Secrets murder trial, South Carolina versus Zachary Hughes. Yay! That is such an interesting trial. If you've not been watching, you might want to come hop on over after this. I have this stream going live, and I also have the other stream live. So we are doing a dual live. Yay! Do a live. So we are waiting for Miss Karen Reed to hop in. We are waiting for the trial to start on the other end. So it's just a lot of waiting. I feel like I'm in the military. Hurry up and wait. Hurry up and wait. Go figure. So thank you guys for liking and being a part of this live. I greatly appreciate it. This one's gonna be over here. Um, for those of you who have not watched Channel 25's live interview with Miss Karen Reed and her attorney, y'all are missing out. You guys are royally missing out. And I mean royally missing out. Did I just accidentally? I've got a lot up and running right now, y'all. A lot up and running. Let me see. Okay, sorry, that has nothing to do with me. Yay! We're all good. Can you imagine how good we are, y'all? We are so good. Y'all, we are so good. We're good. We are so good. I started to say this on my other stream. I'll go ahead and do it on both of these. I am so appreciative of everybody's understanding yesterday. I could not go live on Sunday. Yesterday, I couldn't teach class. I've been sick since Friday afternoon. And I actually took a COVID test, and the first test said positive. The second one said negative. I didn't blow up into a full COVID um, symptoms. I come to find out I was starting a rheumatoid arthritis flare up along with intracranial hypertension flare up along with allergies. That's what it all ended up being. That's what all of this ended up being. Yes, Miss June is a military personnel, retired military personnel. We thank you to all of our veterans. We appreciate all that you guys do. We love our military. Ah, the proverbial fan. We got it. I'm a military brat. I did not serve physically in the military, but I did serve along with my father. Mm. As always, thank you for your service. All right, here comes the judge. I'm gonna turn that down for a minute. That's a little bit extra loud. We don't need all that.
No, I understand. I'm saying the mic.
Also, I learned something that I
Yeah,
did
no
not
problem. Just let us know when you're live. Thank you.
second day of trial on Zachary Hughes, that the school protection officers, school officers mentioned school put it on lockdown in the Zachary Hughes Rose Puddle Arkansas to ensure that the child of the victim was safe. That kicked butt.
Quincy, yeah, they're friends. Yeah, that's what I saw her and Jean Marie. They're by the court.
Yeah, I don't know. That fan was pretty nasty and disgusting.
Wasn't long ago.
I just saw by accident a man getting bit by an alligator. Took a chunk out of his side. Wow, that's creepy and scary. I hope you guys stay warm. I know we are getting ready to get into some really nasty weather. All of you, please stay warm, stay safe. Don't do or get out unless you absolutely have to. Oh, Karen Reed. Something that was said in her trial, in her interview that got me a little bit suspicious. Do you know in this county, the the trooper, the state troopers are in charge of the jury, and the person who is supervisor over all the state troopers mm, was also supervising the jury. Is that not a conflict of interest here? I just want your humble opinion on that. Is that a conflict of interest? I thought, I have I don't have Navy, I have Coast Guard. My father was in the Coast Guard, God love him. He was a coastie, and dang proud of him. A lot of people, um, don't realize what the Coast Guard does for our country. I, sorry about that. I'm looking up some stats here, trying to figure out what's going on with both trials.
There's probably some distortion on that. So listen to that one.
Navy retired.
How are you? I'm going to give you this phone. Last time I shook hands,
Well, we appreciate you.
yeah.
Yeah, a lot of the military looks down on the
Okay,
Coast
plan
Guard
for
as
yourself.
far as my personal
You going to be speaking
experiences.
today?
I'm sure there's a lot of military personnel that like the Coast Guard, but there's a lot that don't. So you people don't realize it's hard to
There's
get
a
in
lot
the
to
Coast
cover.
Guard.
Yeah.
Many people don't make the cut. They're very selective. My father was a chief petty officer, something another. I don't remember what all, but um, he had an important job. I do remember us constantly. Well, we moved. Every year of my school year until my ninth grade year, I went to a different school. I never spent more than a year and a half in one place. Oh, thank you, baby girl. My puppers just came up and gave me some loving. Gave me some loving. What did I get loving for? Go lay down. Go lay down. What do y'all think about my new thumbnail for the Karen Reed trial? I was trying something new. I really like the black and white, but I thought about putting some color in there somewhere, but I didn't. So give me your opinions on the new thumbnail. Uh, oh, I gotta find a better.
I've got it. And it took me over years to get it. Well,
I don't think that this helps. The old building and
that's right, the HVAC system in those buildings are no good. And we spend all our time in courtrooms, close by, you know? Right. Oh, you should get, you know, some bacteria and viruses out. But, you know, also, everyone's close together with their
sometimes it's hard to get.
What's taking them so long? That's what I want to know. What's taking them so long? Let me put that over here. Now, all the trials we're on a pause. We are on a pause. What are they doing? It sounds like they're rearranging the room. Hello, are you getting ready to move the camera and microphone around a little bit?
Just a reminder about cell phone use today, make sure everybody's cell phone is in the mute, please.
What is going on, y'all? Okay, the fan is we're having a merry-go-round with the fan. Just FYI, that's all we're doing here. We're having a merry-go-round with the fan, the proverbial fan. And I want to sing the wheels on the bus go round and round, round and round, round and round. Oh, I want to do that so bad. I hate that song. I hated it as a kid. I hate it now. And look what popped up on my. No sooner did I say that, this popped up on my phone. Let me get to it. The wheels on the bus, it showed it going around and round. That was so funny. Okay, I did it. Let's see if I can bring it up. Okay, it looks like we've got some.
All persons have any business before the Honorable Beverly Cannoli, Justice of the Norfolk Superior Court, and for the County of Norfolk.
Can you all hear
Give
that
your
okay?
attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge 22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Morning, Ms. McLaughlin.
Adam Island for the
Morning,
Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank
Morning,
Brennan.
Mr. Hutter.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan
You're
Jackson.
singing
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
little.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, I was told council wanted to see me outside.
Oh,
Briefly, Judge.
Okay. I want to take this moment to give a huge shout out and thank you to Ms. Carmen Sponovece for being a fabulous mod and for being here when she can, because her work schedule is so cray-cray, and the fact that she loves us enough to spend her free time with us and helping me out. I love you. I appreciate you. You are simply amazing, my dear. I hope you like it. What you thinking, doll? Oh, now we got a close up of. See, now you know why I want your photo, so I can actually thank you guys publicly. Uh huh. Good morning, Miss Cameron. Good morning, Case One. Good morning, Sunny Day. Good morning, June. Good morning, everybody. We're here again for my shite show of a court to see what. Oh, good morning, Haley Mouse. Oh, I just hate the way she sings it. Like, good morning, good morning, good morning. I would just say collectively, good morning, y'all. And that be the end of it. But they have their formalities. Where? Over here. No, over here. Lay down. Sit down. Down.
All right, so what I'd like to do is start with, now I don't know if you all have the paper numbers on these. You probably do if you've been looking at Mass Court. So Commonwealth's motion for records, WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
Good morning again, Your Honor.
Good morning.
I spoke to Mr. Albano last week and again last night,
Okay.
and on behalf of Fox, Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until March 1st to receive all of the information. I expect they'll file it with the court.
Okay.
And so with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can get it here? Was that
Yes,
the
they
date you
They'll
said?
have it on or before March 1st.
Okay. All right, so that motion is allowed by agreement and the order is right here, Mr. Clerk. All right. Next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that, right? On the 10th of February?
Yes, Your Honor.
Okay. All right. So paper number 483, this is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number?
I do, just a second.
Okay.
I didn't get all of that, but I got a lot of it.
I'm sorry, the opposition chief.
Defendant's motion to compel production of a forensically sound copy. We'll get started in the argument and you can give me that.
506,
Great, thank you.
that's the response.
Right. Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions, meeting with Mr. Brennan after court the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present if all the information was a download from some iCloud account, unnamed iCloud account. As long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We're predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system.
Why was
So we want, that's fine, no problem, download the videos, but we want the metadata and the log files.
Okay. Do you remember they sent an investigator down there to get all of the files and everything, the metadata, the file, the video, all of it, right? And they said that there was nothing to be had. The defense spent $12 grand for naught. And then Bev denied their ability or right to recoup that money because they were sent on a wild goose chase. Now they're saying that within the bowels of their system with that video was held. So was that a waste? I don't know. I would reiterate the need for reimbursement for that situation, because to me, I'm like, okay, honey boo, we have a problem, because we sat there and sent a private investigator, and I just lost my needle. Oh, I got it. Sent a private investigator to get the documents, to get the metadata, to get everything that we needed to get, and you guys denied having anything. And now you're telling us something has appeared out of the blue? I'd be fighting like hell for that money because all that money is donated money.
That are associated with that. If it's on a formal file
Yeah,
system,
my
it's
camera.
going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR.
Yep.
Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of the Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that, in fact, it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information. It's exculpatory information. The audit trail is also Brady and exculpatory, because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that, because we would think that in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
Mr. Brennan.
It seems like another effort to portray some type of injustice wrought upon the defense, that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would they be 3 years later? And after they filed a motion making representations that weren't accurate, I no longer had the confidence to have off-the-record agreements with the defense.
Woo!
There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background,
Words, y'all.
when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process. And I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM
Why
Petro,
would whoa?
that
whoa,
he was the
whoa.
officer who would download.
Why would a retired sergeant? Why would you have a retired personnel in that office at that time? Why? I want to know, why was he there? That's not normal.
Video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sally Port
Anybody
area,
want
he would download it.
same question I
What he
have?
told me is that that is
Why?
on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seems if it's on videotape, it can limit baseless allegations later. So we were happy to do it. And then when we got back to the office, the request changed. Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay has been because they've asked for all these different accommodations and different styles of doing it. And so we want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
How quickly can you do that?
I imagine we could do it one day, but today is, we have it done by the end of the week.
You want to make, I'll be heard briefly,
Yes,
very, very briefly.
take your time.
Thank you. Mr. Brennan's confidence notwithstanding, I don't know what to say about that, pretty immaterial, what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. We're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, again, pontificating about how they've been oppressed, I think is his word.
I think that he's right on this point, that it's not the video that he's concerned with as much as the metadata. So here's the thing. It is now on an external hard drive. It is no longer on the original format, right? Now it's in an external hard drive. That external hard drive is now been out of the chain of command. And if I'm wrong, Carmen, nail my butt. But who's had command of that external hard drive? Who's had command of that? Who's had control of that? Has that been sitting in the control of the retired officer? Well, number one, why would he maintain that? That is evidence. Number two, why is it such a big deal to give them the metadata on the hard drive? See, they're saying there's no metadata. Well, there's maybe not metadata on the original captioning device because it's been rewritten. But there's a lot of metadata on that external hard drive. And guess what else is on that external hard drive? A lot of things. And if they sit there and get the metadata for the external hard drive, they, i.e. the Commonwealth, risk opening up some things that they don't want to open up. If I'm not right, tell me I'm not right. You can argue it if you want. But the problem with the chain of custody, here we go. The problem with the chain of custody, it's easily could have been tampered with. It should have been sealed, stored properly. That's what I'm getting to. That it's been sitting in the hands of a retired PD person. You don't know what he's done to it. You don't know who else has had it. And so now this is tainted evidence that should have been given to them well before all this happened. It should have been given to them in the last trial. This data and all of this information should have been given to them over a trial ago. And they are just now getting to this. To me, this is really bad. And the fact that you have a retired military personnel who isn't in the books, who isn't being paid, who isn't working, and he's sitting in the office, why is he even involved? If he's a witness, fine, but but he shouldn't be there when all this metadata is dealt with. He shouldn't be there when all the evidence is being talked about. He shouldn't be a part of this, especially if he's a potential witness. Carmen, tell me if I'm wrong on this. Carmen, how many times do you see an agency with a retired personnel bringing them in or allowing them to come in and sit in the department while they're dealing with a case? He shouldn't have knowledge or access of any of this. So that's problem number one. Problem number two for me is the validity of this video, and on top of it, what's been changed. And again, it should never have been left in the hands of a retired personnel, ever. So I understand we have a new prosecutor on the case. I understand he's walking into a time bomb. I understand there's a lot of stuff that he didn't know happened, and he's playing catch up. And that's wonderful. Thank you very much for taking this on. However, it does not negate the fact that there's evidence that was not turned over originally to this team for Karen Reed, and it was known about and it was hidden. Yeah, we would be fired, not charged if we allowed someone in during that round. Oh, yeah. And why is this still in the possession of a retired police officer or detective? He's supposed to leave any and everything. Well, he's never supposed to take anything home. He's never supposed to have external hard drive that he can take home. I mean, all of that is the property of the state. Why does he have that kind of unfeathered access to it? I would be fighting like a little witchy hyena on this.
Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial,
yeah,
we get
where
more
did it
video.
all
That
come
was
from if
being
it was
inferred.
rewritten over?
Where did that come?
That was the other thing. You would lose your clearance, fired, and probably prosecuted. Exactly. And what about this, Carmen? You're just days away from trial, even in trial, and this video evidence is coming about. Why? Where did it come from? If you guys say you don't have a master, what I call a raw data, a raw copy of the Sallyport video, then how in the hell are you reproducing all this for trial? If it was written over after 30 days, you're telling them, the defense, there is no raw file with the metadata, but yet you're able to produce all of this evidence and videos that suit and fit your needs? That's bullshit.
Come from. Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking.
Exactly.
And Mr. Brennan should want
That
the
October 24th,
fourth.
did that video come with the metadata?
No.
Whoa!
It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, and again, I'm no expert, my understanding is that hard drive will likely have some sort of an EXE program, an executable program on it.
Yep,
To
it
play
does.
the video or to store the video.
Yep,
It'll also have potentially some sort of video player, maybe a proprietary player on it. And then there's going to be the file. So that's what we're asking for. What is the metadata associated with all those things? It's not a hard ask. It's not a heavy lift. There's no reason to justify, well, you know what, I'm just going to drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we
Look at her
invited them
smile on
to
her
come
face.
to the actual hard drive
Like, Bill, you're
and do it themselves, and they
not.
declined. So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type.
How do you not
So
have
they're asking for certain
metadata
things that
on all of this
I don't think
when
we
you're
can comment.
producing it in court?
If they want to come, they're invited.
Yeah, at the tune of
Court wants me to
$12,000
inquire
of waste.
a retired sergeant detective about metadata, I'll do that, but the issue is going to become that when we drag and click these videos, and if there is no metadata or logs or what they say they're looking for, there's going to be yet another accusation. And I do not want to invite
You're right.
this
Why?
accusation.
Why? Where's the raw
On our
data?
duty. Our duty is to provide the videos. What more can we do
I'm sorry, I'm
to
getting
invite
hot,
the
y'all.
defense themselves to come into the Canton Police Department and take a look at the system? So if there's something they want, then we'll copy it.
Good one, Carmen. Good one.
Thank you very much.
She's like,
All
oh,
right,
yeah.
Ms. Giannetti, the next one should be fairly quick and simple. The motion for Pro Hoc Vici. I asked you before when Mr. Alessi joined us, you have a rather vague, good cause exists to grant this motion because Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature.
What?
I asked you last time what you mean by that. I need another affidavit. As soon as I get another affidavit, that
I want to go back to what she says so I spell it right.
fairly quick and simple. The motion for Pro Hoc Vici. I asked you before when Mr. Alessi joined us, you have a rather vague, good cause exists to grant this motion because Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that. I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Understood. And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Okay, thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel?
I don't know how to spell what that was. If anybody else knows how, please let me know. Prohavici. I don't even know how to spell that.
Thank you, Your Honor.
Okay, the next one's paper.
Maybe her brief.
Yes,
Maybe her brief.
yes.
Like, I'm so done with this stuff.
So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay,
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about
Conflict.
for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history
Turtle
of
boy.
documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this
Oh,
case.
but you're not the lawyer for the other
Not
side.
unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow is representing him for. Now,
Whoa.
it's not great
snap.
clarity, but it's been represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a
Oh, snap.
record
This is
that
good.
has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case, that there's an ongoing long-term implicit mutual assistance and mutual defense that they've been a part of for a long time.
Oh,
Now, the
snap.
Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation of protective orders in this case.
Oh, I know where he's going now.
And the discovery in this case was provided to
So much fun.
special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery.
Trying to keep
And
that
much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow, who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings.
Boy, he's making
And
a good
some of that
argument,
information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage. And I am worried, and I have good reason to be worried about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this information, if a court order won't protect it, then nothing will. Then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each. And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so while I do not object to Attorney Betterow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse. And that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object.
Do you really believe that that they have been harassed to the level of which they are speaking of? I wonder because there's people on the state side that have harassed and bullied Karen Reed and their witnesses, have there not been? And you don't see them going up there and crying and shaking a fist and having a baby temper tantrum. I think that what's happening with Turtle Boy sucks. I don't necessarily agree with it. Do I think that he sometimes goes a little overboard? Do I believe that he sometimes has a mouth that will make a grown sailor blush? And some of the things he says are very crude and rude and very hard to hear. But if you listen to the underlying tone, he's correct. How is that bullying? I can't defend him. I don't know enough about his case to defend him. But I think what they're saying here is a bunch of babies.
But the Commonwealth is entitled to.
Wham,
The Commonwealth is entitled to a fair trial. And the witnesses are entitled to walk in this courtroom without being abused.
They haven't been abused. They've abused him. He's never abused them with them walking into the courtroom. I've
Ms.
never,
Giannetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Right, we'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one I believe is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss and/or Metro Corp. Relatively straightforward, but I'll hear you, Mr. Brennan.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it
And Ms.
transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay, there's no objection to this, is there?
No, Your Honor.
Of course, I'll provide a copy if they want.
Yes. All right, so this is allowed. All right, so the next is paper 490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from attorney Mark Diller on behalf of the O'Keefe family in response to defendants Rule 14 and 17 motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Ave in Canton to conduct independent testing and analysis. I assume counsel has seen this affidavit of Mr. Diller?
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today. And today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us. And I would ask that the court take no action on this motion until we've had a chance to view them. And we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested.
Understood.
Okay. All right, so no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses. And that's what we're asking the court to reconsider. It is our position, Judge, that, part of, and I believe I quoted a case on the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to, Ms. McCabe, it was never mentioned anywhere that she spent an hour at the home, the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data, which revealed that that meeting did take place. And so, the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. Secondly, with regard to the juvenile witness, as the court remembers, I'm sure from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, we question what was done behind the scenes to, arrive at that conclusion as well. I also, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed. So I take responsibility for everything that's in there. But we also make the point that with regard to, Trooper Proctor, it appears as though there was, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument. And he obviously uses derogatory language toward him as well. If we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but this is I won't say unique trial, but it's a rare trial that is streamed online. There's obviously a lot of
Be
press
careful
interest.
here. You may talk your
Some people
way
are
out of
watching,
having it live.
everything
We're
that
allowed
goes
to
on. The
talk
court has
about
issued
that.
sequestration orders. We don't know for sure whether they've.
Okay, here's the problem with his argument. Right now, he is putting it in the boat that she could just say, okay, no live stream. We took care of that. Bye. Done. Please, God, don't let
been
that happen.
complied with. And to the extent that we turn over this impeachment material and the Commonwealth uses it, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward cross-examination.
You're treading on very thin ice here.
Switching to the Commonwealth's motion for sanctions.
Let's wait. When I said both, I thought you meant 2 points that you made both.
Understood.
All right, so, Mr. Brennan?
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony.
Thank you.
Just like the Commonwealth
you,
provides
Judge.
all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes there are names on them, talking about theories of the case. I give it to the defense because it's in my possession, custody, or control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If you look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the
And
defense.
you've been a
They're
fair
entitled in
play
state
vote,
court
you.
anyways. Federal rules are very
Not been
different.
fair play.
In state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides. And that should not change.
Yeah, it
would
wasn't
it's
followed by
going to
your
create
side more than
chaos.
their side.
It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place.
Nothing's going to
and then
be
hopefully at this
on
trial,
the side of
will
Karen
be
Reed.
abided by.
Nancy Bev is going to decide for
Okay.
the prosecution the whole way.
Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. No, the only thing I would point out, Your Honor, is that with regard to the report of Jen McCabe, or Jennifer McCabe, I should say, revealing this link meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
Thank you.
I've been on the side where late discovery.
Oh, don't give me
I
that
never
crap.
want that to happen.
I'm so
Sometimes this
glad.
happens on both
I
sides.
came in
That's not in the
late.
hands of the Commonwealth.
I'm doing my
Doing everything
best.
possible
I'm doing
to
everything
give
I
the defense
can.
more
It's not
discovery than they're
me,
entitled to
it's
or
them. Oh, sit down
All
and
right.
shut up.
Thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Your Honor, we filed a motion to compel certain discovery that is still outstanding. There's 10 items. I'll address those in turn. The first request deals with,
So you have the Commonwealth's response, right?
yes,
Where it doesn't object to some. Are you going to skip over those? Or
yes, of course,
okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage. Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have video surveillance footage from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those three productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those three productions, or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State Police officers.
Yeah,
who
that's
handled
why I'm
this
thinking
footage.
about going to law school.
They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos, but that does not absolve them of their Rule 14 obligations.
Good for
We
you.
still don't know who the
Good
custodian of
girl.
records
That's
is.
a great point.
The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
For those of you who do not know,
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There's certain names that this court will recognize. First responding officer, Sergeant Link. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper Garino. Lieutenant Brian Tully. Trooper Kathleen Prince. And Norfolk County District Attorney Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect.
woo, she opened that can of whooping.
Specifically in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes, and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again, deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore. No evidence of improper conduct, nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right. Mr. Mr. Brennan.
All right, here comes the crybaby. Well,
It's important
Carmen,
to represent facts accurately. And the court has ordered in the past when representation.
Carmen, one thing that people are forgetting was when the victim passed away on the lawn of a police department. They, i.e., the Commonwealth, the PD, the state troopers, all said that they were going to be calling in an outside agency, that they were going to step back because it's a conflict of interest. But what did they do? They did not step back. The feds are in for they're not in investigating the unaliving of John O'Keefe. They're there investigating the department as a whole. Two totally different investigations. And people said, well, the feds haven't done anything yet, so everything must be fine. Oh, no, the feds have done a lot. In fact, they've turned in certain evidences that they have that they can turn over to both sides for the case, i.e. the reconstruction of the vehicle that night, all of that. And the witness for the feds said that they could find no evidence that John O'Keefe was hit by a vehicle. After all of their reconstruction. The problem is that the feds are lying in wait. So I imagine, and you can tell me, Carmen, if I'm wrong, that sometimes feds will sit there and watch what happens in a court proceeding in a criminal court to gain more evidence and to see what comes up before they put their own case in chief up and go after people. This case will be settled and done, and then I suspect we'll have the feds hopping on the boat, and it will be sinking very quickly for Canton PD. I understand. I don't disagree with you, Carmen, at all. I've had the same question. I just don't have an
Have
answer.
been made that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to number one. Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing that there is no witness for. The defense has asked for chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot
Why
invent
does it
a
not exist?
chain
It's
of
supposed
custody
to
that
exist.
is not in writing and there is no
Hi,
witness to.
evil queen. Hi,
I've done my best to be thorough and diligent,
Penny.
and
Oh,
they will receive a
sunny
report and
day.
have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to then now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case.
His credibility has everything to do
And
with.
so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience.
Oh, what?
And so the reality is the Birchmore case is
No.
being investigated by federal authorities.
Did he bring us up? Did he just do that? Did he just say that about us? Did he just throw shade? Oh, that was some shade.
There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim.
Careful what you say about her case, because it's
Number
under
4.
investigation too.
Unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why?
Oh,
Why that
you are
case?
so right about that, Carmen. I've missed you,
Troopers work
Carmen.
on many cases. That case certainly has a public appeal to
We
it
still need to do another Sunday Night Live.
because of the
I had some
harshness
fun
of
with
it,
you.
the sadness of it. But what does it have to do with this case? Nothing.
Oh, it has a lot.
But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under
Well,
Graham.
I still
I-
can come up
I
there.
had a
and see you,
conversation with
girlfriend.
defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when
Oh,
it is,
again, you blame
if
the
it is, I will be there and I'll advocate for them for this information. In
Oh,
addition,
Lord,
there's a Rule 17 that has been ordered by this court
I
that
don't believe
imposes
it.
an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability.
Which
I
means
sent
my
an email
ability
on
is
January
limited to
28,
my ability.
2025 to a number of attorneys at the state police.
Once my grandpa, I don't know who said it, but somebody said something to my grandpa. Oh, I'll do it to the best I can or best of my ability. He goes, the best of your ability is what you choose your ability best to be. So you best do your best ability or I'm going to be on you. That was very wise. Your best ability is what you choose it to be, not necessarily what it is.
And I informed counsel in view of the Commonwealth's responsibilities under Brady v. Maryland and Giglio, and most recently set out in McFarland and Graham. The Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to
Hello, Chris.
inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth v. Karen Reed.
Hello, good evening.
All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024, please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material.
I doubt
The
that we
defense is
have.
entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty.
How many of you, by
Number
the show of
6 and
hands?
7, we do not object.
Who
Number
believes-
8, there is a difference between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there is a difference between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts
I
and
agree with you,
me
Tom.
cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA, and again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week, and I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
Are we believing his BS, yes or no?
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that under advisement.
Oh, of course, you won't give in.
Do you have that Rule 17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean,
I
we're
can
over
give that to the
500 at this point, so.
Yes.
All right. All right, so next we'll move on to the so-called ARCA motion, Commonwealth's motion to exclude employees of ARCA, paper 497, and the opposition 505. So, Mr. Brennan?
How do you spell ARCA? A-R-K-A? A-R-C-K-A?
Sure.
A-R-I, okay, got it. We got it. I'm trying to do in the description motions in order so people want to zoom, they can. I'm trying to be a little better YouTuber by providing a little more information.
Your Honor, my purpose is not to deprive the defense of an expert
Yeah, it is.
or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. there has to be full disclosure when calling an expert.
To the gym without your consent.
It's
If
interesting
you feel tired, this is why.
that the
Oh,
defense's
that's good.
position is that the information's unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert
Oh,
witness
I
that
knew
they don't
money
know
was
about,
gonna come
they
into
can't ask about. That there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be
Oh,
a
man, you're
proponent
throwing
of
disgrace.
those witnesses, they have obligations, Rule 14 obligations for basic discovery.
Back to Rule 14.
I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request.
Yep.
It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
Woo.
Transcript is this.
On page 2812 and 2813 of June 10, 2024.
Oh, wow. He's throwing a lot of shade.
Now,
Yeah.
having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial.
That's
So there is
our-
email correspondence between the defense,
not our problem.
not only the federal government, but the ARCA witnesses
That's a personal
themselves.
problem to me, sir.
A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
So do it again, Sam.
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated.
That's
It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them.
This does not look
Have you
good.
qualified as an expert in
This-
court before? Yes.
Look.
I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up.
It is
And
now.
then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts.
How much you want to bet he
Illusions
wins
and
this
shields
one?
and say something's
they-
there and something's
they lose.
happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the
Then why
Commonwealth,
do you
like
care?
the defense, is entitled
We'll see
to
that.
discovery. So if they can produce the
You don't
discovery,
trust the
I
jury?
welcome ARCA.
All right, I'm going to take a recess before the response.
Court, all rise, please.
Oh, potty break, stretch break. What do y'all think? They're gonna have a lot of explaining to do about that piece of paper. That's how I feel. I feel that that paper, what he just read, could be a little damning. But what was his response? No, you need to tell the truth. We don't have secrets. I think the fan is still dirty. What do y'all think? Is the fan still dirty? Does the fan need to be still be cleaned? You would think they would have cleaned it before, especially after all of us joking about how nasty it is. Just saying. Wow, that last one's a good one. That didn't look good at all. But what was his responses to all those questions? Should I have informed them? Should I tell them? It's yes. If asked, you answer every question asked of you, and to the honest as possible. Yes. I mean, if he was hiding it, how did he get that paper? The defense had to give that to him. Still dirty. All right, Miss Carmen, you want to hop on? Oh, dang it, every time I poke myself, it's because I look away. That diaper's starting to stink a little bit. Mm. I am wondering how many this is what I have in my head. Maybe I should take a poll. What percentage of the motions are gonna be granted for the Commonwealth, and what percentage will be granted to on the side of the defense? I don't have very much hope, y'all, because I don't see Auntie Bev do alright, refresh my memory, y'all. Where, if any, how many of the motions on Karen Reed's side has the judge, granted versus on the defense's side? On the Commonwealth versus the defense. What do y'all think? I would guess only maybe 5 to 10%. I know, right? This is the only argument that I think really hurts the defense in this. And what he read did not look good. Although I remember went on a case that I was to testify on. Hold on, I gotta ask my son a question. Bye. All right, my son has an appointment today, and I'm gonna later on help with the shop, so I had to find out when all that was gonna happen. My question is on a lot of this is, um, I don't know why Auntie Bev takes so damn long to come make up her mind on anything. My document fairies, we're gonna have to be on the ball. I have tried my dangdest to access records for this case, and I don't know why I cannot. I can get to the website, I can see stuff, but I can't get the documents, and I don't are they paid for? Can someone answer me that? Are these documents paid for? I didn't know. Hey, Haley Mouse, you nodded off listening to him? Girl, I wish I could nod off. But I am on a time crunch with this beadwork, y'all. I was on a time crunch. And I have got to get this stuff done. I did 3 of them yesterday. This weekend, I did 3, maybe 4 out of the 10. I got 4 or 5 more to finish out of the 10. That's these. I'm blacking out. I think this takes the longest is the blackout, the bead blackout, where you go in and you stitch every other bead. But it's okay. It's worth it. In the end, it's lovely. So, just FYI, this Friday, just a reminder, I will have to make some time where I'll be off camera for about an hour. I will need a mod because I will be filming a recorded show with Tanika. Everybody remember Miss Tanika? We will be talking about the Karen Reed, and it will go live on her channel. I'm going to see how we can get it live on my channel. When it goes to her channel, see if we can get it on my channel so we both can benefit from people watching it. But Miss Tanika is a sweetheart. But we're not going to be on Sarah Boone, y'all. We're not going to be boondogging it. We're going to be doing Reed. She's going to be talking to me about the Karen Reed trial. Hence why I'm so involved. Well, I've always been involved. But Miss Carmen, do you want to hop on with me? Gladly have you come on. If you choose to. I know you're probably getting ready to go to work. I don't know how you're doing it. This weekend, I did get a lot of sleep. I really have been struggling since these cold fronts have been coming through with the arthritis pain. Y'all, it's getting real. I mean, if you don't know what RA pain feels like, you are lucky. This stuff gets real. If I had to go do any kind of major walking, I will definitely be what's called wheelchairing it. I will be in the wheelchair because it is that painful right now. We have, I am in the process. I'm going to take a break from this. I'm going to try and make some cute little things. I want to give a shout out to Grandma's house. I had fun the other day, yesterday. I beat Haley Mouse. She had a game where she talked about it was all about the presidents of the United States. I can't believe I got 22 out of, was it 30, 35 of the questions correct. I guess the history class I'm forced to take is helping. For those of you who don't know, I am going to college right now. I should be doing some work right now, but I'm putting it off for tonight. But I am studying criminal justice. Who knows? I may be the next Carmen. I have this thing that's on my seat that heats up. Feels so good, but now I have 2 wires hanging from my back. I got my ears, and then I got this thing. So I'm all plugged in. Okay. Let's get going. why are we having I don't understand why we're having a short break, but I think what I'm going to do is, got that? Ooh. Excuse the yawn, y'all. Ah, that's what I let down. The Simatilli trial has started. We will watch that tonight. I want to watch this.
Kentucky Sheriff Mickey Steins has been locked up since last year after taking out the local sitting judge, Kevin Mullins, inside his chambers. The incident took place in the middle of the afternoon. Earlier that same day, the sheriff and the judge had eaten lunch together. After the shooting, the sheriff surrendered immediately, but what's still not clear is why he did it. Some people suspect it was connected to the sex extortion that was taking place inside the judge's chambers after hours, which brought charges against a deputy and resulted in a civil lawsuit against the sheriff. But now many are wondering if the judge himself was involved in this extortion for sex scandal.
There was this toxic mixture of sex and extortion in the courthouse. My client was forced to have oral sex and sexual intercourse in the judge's chambers.
But he does have some videotapes of some stuff in the judge's chambers.
What kind of stuff?
Just with girls, sexual and stuff.
What describe? Have you seen the videos?
I've seen one partly, and just him having sex with girls for the able to get out of jail.
Who was having sex?
Ben and just some higher ups up there.
Who?
The judge and.
You saw the video.
Yeah.
What did you see on the video? I mean,
I've seen there's all the time sex with a girl.
Who was the girl?
I don't know. Because I don't know a lot of people from over.
Where was it at?
In his office, in the judge's chambers.
Is that the same place that you were meeting Ben? Is that how you know it was the judge's chambers? And this was Judge who?
Mullins.
This is explosive type of information. Talking about a judge, a sitting judge doing this. And she said she witnessed it on a video.
This audio you played, I was actually there. What happened was after we filed the lawsuit and before Fields was charged with the crime, the Attorney General's office made an appointment to come to my hometown of Prestonsburg and interviewed Sabrina. And what it is, Vinny, is called a proffer. And it's important to understand what a proffer is. A proffer is when the prosecution wants to find out every information they can find out. They ask all sorts of open-ended questions. Proffers are different from what's in a courtroom where you're only allowed to talk about what you think is admissible evidence. A typical proffer is tell us every rumor you've heard. Tell us every double, triple, quadruple hearsay. Tell us your speculation. So it's important for those talking about this release of this audio. First of all, we did not release it. As I understand from our friends in the media, the criminal case against Ben Fields is over because of the prosecution believing Sabrina. They indicted Mr. Fields, and he eventually pled guilty to basically every charge brought against him. After the proffer, the Attorney General's office, and I've had my differences with them over the past, but I give them high marks. They went forward and indicted a popular local figure, the bailiff, Ben Fields, who's referred to. They prosecuted him. They secured guilty pleas, guilty verdicts, and time in jail. So that's the context of how this video got out there.
But you saw the video of the judge. Any other video that you actually saw?
No. They say that the Sheriff Mickey Steins is involved. I don't know.
Who said that?
Chad, he said he had videos with Mickey. Mickey used to do the same thing when he was over house arrest.
How deep do you suspect the scandal goes? Does it go beyond this deputy? And could it have something to do with the actual shooting?
You know, the best way to answer the question is the clip you filed of the defense lawyer.
Do you know whether this is connected to the federal lawsuit he was a part of? Is there any connection?
I think that the timing of what occurred is certainly something that is going to be a crucial point in this case. The timing of the deposition, amongst other things and other background information that will complete that story. But I do, yes, to answer your question, I do believe that that is a piece. This is a large story. That's a story that in some ways is difficult to tell. We look forward to sharing a more complete version of that as we go through this judicial process.
Mr. Former Sheriff Steins is well represented, very good lawyer, and the first question you would ask your client, why did you do this? He knows what Sheriff Steins told him. The video clip you showed seems to indicate that, yes, it is tied to my civil case.
And can you describe for us what happened immediately prior to the clip that we saw?
Sheriff Steins uses his telephone to make some phone calls. He then borrows Judge Mullen's cell phone and appears to make a call on that. And that led to what you just saw.
There is a point when Sheriff Steins asked for to see the telephone of Judge Mullins.
Yes.
Are you aware of any recent content that was up and could have been relevant at the time of their discussion?
I was told that Sheriff Steins had tried to call his daughter, and he had tried to call his daughter from the judge's phone also.
Have officers confirmed that the sheriff's daughter's phone number was on Judge Mullins' phone?
Yes, I believe so, yes.
So that number had been called from Judge Mullins' phone?
Yes.
Is that correct?
Yes.
He tried to call his daughter from Judge Mullins' phone, and it actually came out, we were under the impression after that hearing that the number of his daughter was saved in Judge Mullins' phone, but according to the local paper, the Mountain Eagle, the number was just dialed on Judge Mullins' phone. But when he got arrested, Sheriff Steins, his first statement to police was, they're trying to take my wife and kid, which is a direct correlation. Tried to call his daughter right directly before the shooting happened in those chambers. And then he sat around at the courthouse outside of his chambers, waited to turn himself in. And then the first thing out of his mouth is that they're trying to take my wife and kid.
I do think the really interesting point is, Vinny, Sheriff Steins does not want to change a venue. You know, think about that logically. If a random person who, for whatever reason, shot the judge, you know, usually when it happens, it's usually a domestic violence. Somebody's irate. The last person, that random person, last place, that random person who would want to be tried would be in a small county where everybody knew a popular local judge. That person would want to change a venue. It's astonishing in this case, not only to Mr. Bartley, who is a well-regarded lawyer. He said two things. One, he said it was related to my civil case. Two, he said, I don't want to change a venue, which tells me there's some sort of almost jury nullification defense brewing out there. You know, my thought really as a criminal defense lawyer, I've only been a criminal defense lawyer in Appalachia for 43 years. I think there is some sort of jury nullification defense. Self-defense is not in the cards, obviously. Him tying it to the civil case I filed. And the civil case I filed, it's a civil case. This is our side, not the other side denies it. Makes some sweeping allegations.
The sheriff has not publicly revealed his motive or his defense, but is being evaluated by a mental health expert to determine first if he's competent to stand trial, and second, to determine whether or not he suffered from any reduced mental capacity at the time of the crime. I'm Vinnie Politan. Thanks for listening.
Woo, doggy. This is going to be cray cray. Okay, let's get back to the proverbial fan and get back into court. Y'all, this is going to be good. This is going to be good, good, good. All right, let's see. I'm just a few seconds behind. I did pause that briefly.
May have profound effects.
Oh, shoot. This may not be good. I'm nervous for this now.
Back to session, you may be seated, make sure your cell phones are off and put away.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
Oh, shoot.
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever
What time did she say?
you're
11?
dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now.
Did she say 11?
Less than a minute. The chronology is just.
Let me back that up just to make sure I understand.
These have been kind enough in the past to allow. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
Wow,
Again,
what do
there's a
y'all
brief
think?
chronology I think Your Honor should be aware of. If I could add that right now.
What are y'all's
Less
thoughts?
than a minute. The chronology is December 4th. We sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts.
Bingo!
And
That's
that
the problem.
if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage.
And
On February 11th, we filed the motion to exclude.
And it hurts the defense. Why? Because now they're going to have to pay them to be an expert witness. And they can no longer say this is a non-partial, non-biased group because we are not paying them. So now this will change the demographics on how this information is received by the jury.
13th, the defense provided us the emails that I read, February 13th, 2025. I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. we reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
Your Honor, if I may hand up the discovery that was
Thank you.
provided by the defendant reference by.
Oh, great, thank you.
Is there any way we should suspend for today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th, even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we could do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not. Ma'am, just a moment.
Thanks. Thank you.
Thank you. Her sighing really gets to me. Woo! She turned a little quick. By the way, Karen Reed's highly involved in her case. In fact, she's so involved in her case, it impresses me why she's not a lawyer. She may become one after this. She's got an analytical mind because she's in finance. She's a teacher. I don't remember what she taught, but I know she's very analytical.
Your Honor, we'll accommodate the 25th, one way or the other.
All right. So we'll see everyone.
Your Honor, I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock on the 25th.
Thank you.
All rise for the court, please.
Now I got to get that on my schedule. Okay, everybody on the Karen Reed Live, thank you so much for joining. We will be back here on the 25th at 12 p.m. Central Standard Time, 11 a.m. on the East Coast, and we will pray that some of these motions come in favor of the defendant. But majority of the time, Auntie Bev ain't playing for the defendant. So we'll see what happens. Thank you again for joining me. I greatly appreciate you. If you would like, come back over to the Twisted Rose Petal trial of Zachary Hughes, Day 5. We will be beginning that in just a few moments. Thank you for watching. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.